Thank you. Please be seated. Justice McLaughlin was unable to make argument today, but as you know, we record our arguments, and she will watch the arguments and is still participating in the case. We have two cases on the docket today, Moore versus the State of Texas. Both sides here and ready?
Yes, jumping in during for Jerome Moore.
Andrew Fletcher from the state, we're ready.
And did you want to save time for rebuttal?
Yes, Justice, probably saving 3 minutes.
And our second case on the docket is Nelson versus Houston Methodist Sugarland Hospital. Both sides here and ready?
Yes, Your Honor.
All right, thank you. We will not take a break between arguments. We are ready on Moore versus the State of Texas.
Chief Justice Christopher, and may it please the court. Jerome Moore was convicted of the aggravated robbery of Keith Ward, which is believed to have happened on April 5th, 2021. There's nothing in the record that suggests that investigators were aware that Mr. Moore was involved in that until after May 5th of 2021. That's when he was stopped as a part of an aggravated robbery and his cell phone was searched. All of the evidence that was used against Mr. Moore at trial, except for GPS location that came from his ankle monitor, came from his cell phone. And one could even argue that because the officers did not know to look at the GPS data from his ankle monitor until after they searched his phone, that too came indirectly from the cell phone. And so the issue of whether the search warrant affidavit was sufficient to establish probable cause is of prime importance in this case. I'd like to first briefly look at the probable cause affidavit at issue in this case, in Moore. And then I'd like to talk a little bit about the dialogue between this court and the CCA that I think started with Baldwin versus State, the en banc opinion issued December 10th, 2020, and continuing all the way till this morning's opinion on remand in Stalker versus State, because that issue that is present in Baldwin versus State and Stalker versus State is exactly why we're here today. After that, I'd like to look at opinions from other courts of appeals. I believe that they're consistent with today's opinion in Stalker from this court, except for Frazier case from Amarillo cited by the state, and I'm about to talk about that too. And then finally, I'll wrap up just explaining why I do not believe that the search warrant affidavit here satisfies the standard. As I mentioned, Mr. Moore was first arrested on May 5th, 2021. Well, he'd been arrested before, but as relates to this case on May 5th, 2021. At the time he was driving a black Challenger. There was another vehicle that was a white Chevrolet Trax, I believe. There were two people in the white Chevrolet Trax. One of them was named Delacy Williams. Another was named Frank Brown. And there were two people in the black Challenger which belonged to Mr. Moore, himself and a person named Terrell Hunt. Now, after the officers stopped the individuals as a part of this sting operation, you see they were scoping out the Galleria area. There had been a lot of robberies in that area. They saw these two cars and they believed that they were kind of acting in tandem, is the word that's used in the search warrant affidavit. It's similar to the term in concert used in the Baldwin affidavit, I believe. He observed them acting in tandem. He observed them pull over, and the white Chevy Trax replaced the license plate that it had on it, or rather put on top of the license plate a paper tag, which did not belong to that car. They then observed these two vehicles following really closely an SUV that the officer watching these individuals believed was going to be the target of this robbery. The officer then watched them speed through a red light to keep up with the SUV. After they stopped at a jewelry store, the officer pulled them over, and that's where they were arrested, taken into custody, and their cell phones were taken. 4 cell phones were taken. The search warrant affidavit that was used to obtain permission to search Mr. Moore's cell phone can be found in the exhibits volume of the record, volume 7. It's the last exhibit there. And I believe it's important to note some items from that affidavit. First, the affidavit specifically mentions the cell phones of Della C. Williams and Terrell Hunt. Specifically, the search warrant affidavit says that the arresting officer interviewed Della C. Williams, and Williams told him that he had contacted Terrell Hunt, and they'd been in communication immediately before the attempted robbery, and they had planned using their cell phones. There is nothing, however, in the affidavit specifically about Mr. Moore's cell phone. There's a lot of information in the affidavit about how the officer observed them acting in tandem, how Della C. Williams had said that Mr. Moore was supposed to be a scout, in other words, picking out targets. All this information was in there. And so there was a lot of information about the crime. There was not one thing said, though, about Mr. Moore's cell phone.
But the circumstances in the affidavit that show the officers watching the coordinated activity as it's happening with two separate vehicles, and Mr. Moore in one of them, plus the fact that Mr. Moore showed up at the scene. Okay, I know the affidavit doesn't mention his phone specifically, but he obviously knew to be there to meet up with these guys. Why couldn't the magistrate have drawn an inference that he used his phone to know to be there to meet these people, and used his phone as he was scouting the area?
I think the clear rule that's still in place from Baldwin and for Stalker is that in order to establish the probable cause, you really need specific details about that phone. And I understand what you're saying.
So you think the rule about reasonable inferences is gone? I mean, isn't that what we're talking about here, reasonable inference?
Chief Justice Christopher, I absolutely do not believe the reasonable inference is gone. And still, you know, we are to, this court is to be highly deferential to the magistrate's findings, right? I understand that. But I do believe that Baldwin and Stalker, continuing on through this court's opinion today in Stalker, all hold that you really need information in that search warrant affidavit about that specific electronic device to be searched. Justice Jewell, there was nothing in the search warrant affidavit suggesting how Mr. Moore came to be at that location. He might have been with Mr. Williams, Mr. Hunt, Mr. Brown beforehand. They might have talked about it then. There is nothing in there that says that that had to be done. Also,
But don't you think the fact that two of the I'll call them co-conspirators, but two of the other individuals who were involved in this were communicating over phone, doesn't that raise the inference that all of them were communicating over phone?
respectfully, I do not believe
You
it
don't
does.
think so? But what about our case in Diaz versus State, where we had the situation with the individuals who were pretending to be cops, and they broke into a house, they all had cell phones on them, they left pieces of cell phone behind, but there was no evidence there that one person in particular had spoken on the phone.
There isn't, and I believe the difference that's made in that case when it's compared to others is that the cell phones were left there at the scene, and that is how the reviewing court, I believe this court, was able to find that there was a connection because they were left there at the scene. And if that is the distinction that makes that search in Diaz appropriate, that is not present here.
And when Moore was arrested and for this incident, this phone was on him at that time?
It was in his vehicle.
Okay.
It was in his vehicle.
Was he the lead car?
No, I do not believe so. He was referred to as the scout. And so whether that put him in the lead or not during the chase, I'm not sure. But he was supposed to be the one, I believe, that was picking out targets. And whether he was first or last in the running the red light, I do not know, Chief Justice Christopher. But I do believe that...
Before you go on, so how would the two cars coordinate with each other if not by phone during the hour or two when the scouting is going on?
I believe there are a variety of different ways they could communicate. I mean, there might be, you know, I'll put on my hazards when I spot a target. I'll flash my left turn signal twice, or if I'm behind you, I'll flash my high beams when I've identified somebody that we can go after. I believe there are a variety of different things they could do,
Okay.
and not necessarily would they need to use their cell phones. And there's nothing in the search warrant affidavit that says that the cell phones were used.
Well, other than 2 individuals use their cell phones.
That is
But
correct,
not
Chief
Mr.
Justice
Moore.
Christopher. And I believe that that is more than sufficient for the search of Delcy Williams' phone and Terrell Hunt's phone. Even if Baldwin versus State meant what this court, I think, originally thought it meant when it first issued Stalker, I think even then it would be permissible. But not for Mr. Moore's, because this is not mentioned there. There is nothing tying it to that. And I do think that that is what is required by Baldwin versus State, as modified to the extent it is modified by Stalker versus State. And that is simply that there has to be something in that search warrant affidavit directly connecting that item to be searched, the electronic device, to the criminal activity being investigated. And there just isn't anything like that in this. There is nothing about Mr. Moore's phone. I do believe that this court's opinion in Stalker this morning, jumping ahead to today, did get it right. I believe that, I only discovered the opinion a couple hours ago, but I do believe that this court's opinion today was grounded in the fact that the officer said that there is a reason that I'm able to suspect that a lot of crime is occurring in this neighborhood. I believe that whoever committed this, we could find their GPS location, we could find where they were, their movement related to this criminal activity from their cell phone. Additionally, we learned from a tipster who had his phone number that he was involved with this. And so it's reasonable to think that Mr. Stalker communicated with the tipster via his phone because that person had his cell phone. And so there it is reasonable, I think, to determine that there is probable cause. Now, was there anything in there that said that Mr. Stalker used his phone during the commission of the crime or immediately before or after, which seemed to be what Baldwin held was required? No, there isn't. But there was sufficient facts, as Justice Jewell and the panel found this morning, to connect that phone to the specific activity being investigated.
So there have been a lot of lower court opinions since Baldwin and Stalker.
There have.
Is there any lower court opinion that you feel is on point in your favor?
I believe all of them except for Frazier versus State, which is relied on heavily by the state. And I will point out that on February 19th, 2025, the CCA did grant a PDR in Frazier's case, and specifically to 3 issues, 1, 3, and 5, and that 3rd issue has to do with this. And so I do believe that the one case that does not go our way is under review by the CCA. Another case I believe that goes our way from the 3rd Court of Appeals is Mason versus State. They're a father, and that's 323-0043-CR. They're a father and a stepmother were accused of sexually assaulting a child, and in that same activity also showing him child porn. The officer said that he needed to search the porn was showed at their residence, and then that's an important fact. And the officer said that he believes that it's likely that you would find this child porn on these devices. And I think that's critical because the only way that child porn exists in most cases is on electronic devices, and so I think that that's reasonable. Does it say that they used this while they were sexually abusing their child? No. But it was a part of that. It contained that evidence. Also, McDonald versus State, not only this court's McDonald versus State from 2024, but also McDonald versus State cited in our brief from the El Paso court on August 9th, 2024. And this is like the tipster at issue in Stalker. And why they were allowed to get into this McDonald cell phone is because they had learned from someone that he communicated with via text that he had confessed to her. Was that cell phone used during the commission of the crime or immediately before or after? No, but because there was reason to believe that he had confessed to this witness using it, then there was a reason to believe that data or evidence related to this crime could be found on that device.
Thank you. You'll have time for rebuttal.
May it please the court, my name is Andrew Fletcher. I'm representing the state of Texas and the Harris County District Attorney's Office in this case. I'd like to go back to what was just at the end there about what's discussed about these other cases. And it's a difference of ideas between what is sufficient and what is the minimum and the floor. Because I think there's a confusion here that the defense is trying to tell this court as far as these things, which actually are more like kind of Baldwin light rather than what Stalker says is sufficient in the minimum. And actually, we're going to talk about the new Stalker opinion and why it and all these cases that have been cited by the defense actually support the state, bar none. So what I would start with, and I think it's key and important here, is actually about the standard. Point 2 specifically in the Stalker's opinion from today is, this link may be shown by facts reasonably indicating use of a cell phone in connection with an offense under investigation and described in the affidavit. Specific facts or circumstances, together with reasonable inferences therefrom, connecting the cell phone to the criminal activity described, has been held to be enough. And what that means and why that is important to all of the cases that the defense cites is that he's citing to express references. That would qualify as far as specific facts or circumstances. That is not, and his reading of Baldwin and Stalker would exclude the idea of reasonable inferences therefrom. We had these notions of what what my opponent has mentioned as far as possible signals that we don't know, flashing lights, things like that. We don't know that. The only question is the idea of cell phone communication a reasonable inference between co-conspirators when two of those co-conspirators, or at least one of the co-conspirators says, I absolutely talked with head honcho about this.
Let me stop you right there.
Yes.
So what if this affidavit did not say that Williams told the police that he and Hunt spoke over the phone? What if that fact was left out, so there was no mention at all of any phone conversation? What you're left with is just the fact that the officers were watching the cars, seemingly acting in tandem, plus more meeting up at the scene. So would that be enough to supply the necessary inferences?
I think it would be a closer question, Your Honor, and even then we would still apply great deference to the magistrate in that decision.
But how would that be different from Baldwin?
I would think, Your Honor, that would be, I do think it's a closer case than what we actually have, but I do think that if you observe vehicles, playing with that hypothetical, see vehicles in tandem going around for more than an hour without any sort of smoke signals or signal birds or ASL, anything like that, you have to come to a reasonable conclusion about them somehow communicating. And it's not just that behavior of sort of traveling around and showing up magically as if, which is what Moore does when he shows up in his spotter vehicle. It's completely inexplicable apart from the fact that he has been contacted. Again, I would say that this is a good thought experiment, but it's not this case. But even with that, Your Honor, as far as the operation of the vehicles in tandem, going all the way through to when they know when to leave together, how to stop together, how to remove the paper plate. When Terrell Hunt, the alleged ringleader of this, moves from one car to the other, to know to do that, to know to then head off to Johnny Dang's jewelry store, to then watch there in tandem, to then pull off in tandem and to follow a vehicle, to stick together. The question becomes what is reasonable. And then, so when we look at what it is, remember that's less than a 50% requirement. I mean, we can look at, I have here just this language from Illinois v. Gates, of course, and Brinegar, and I don't want to belabor the point, but just to say things such as practical, non-technical conception dealing with probabilities, reasonable and prudent men, not legal technicians acting, certain common sense conclusions about human behavior, seen and weighed not in terms of library analysis, but as understood by those versed in the field of law enforcement. A fluid concept, not readily or even usefully reduced to a neat set of legal rules. Seizure made under circumstances which warrant suspicion. Only the probability and not a prima facie showing of criminal activity is the standard of probable cause. Technical requirements of elaborate specificity have no proper place in this area. Means more than bare suspicion. When fact exists, when facts and circumstances within the officer's knowledge and of which they have reasonably trustworthy information are sufficient to warrant a man of reasonable caution and belief that an offense has been or is being committed. These are all statements that are balancing the privacy interest as well as the officer's. And even then, the Supreme Court goes on to say, are more or less ambiguous. Room must be allowed for some mistakes on their part, but the mistakes must be those of reasonable men. Now, I say that acknowledging Baldwin and what Baldwin remains to say about the nexus of an offense. But when you look at this particular case, where we do have what Williams says in the Miranda waiver statement, we have more than is the minimum. We're talking about the floor, basically, Your Honor, when we don't have to worry about that. What I'm going to talk to Your Honors about in terms of the case law and why it supports us is that all of these other cases that the defense has cited are actually much higher, and what we have is much higher than what he portrays as somehow violating Baldwin or even Stocker. So again, what we have here, of course, is we have an observation involving the Chevrolet Trax, that a vehicle linked to several robberies being driven by a guy with a warrant for robbery and on bond for robbery, and with ties to a gang known for robberies. Suspects meeting up with this individual, him putting on a temporary paper plate on top of a hard license plate that was fictitious, not registered to that vehicle, watching this tandem driving, that he and his experience.
Well, is it the tandem driving that you think makes the difference with Baldwin? Because, I mean, in Baldwin, we had somebody scouting out the area, and that wasn't enough.
I would say, Your Honor, that here we have to take the warrant at its four corners. I think that tandem driving is important. I do, because I think that it supports the possibility, even under Baldwin, which of course Stocker hadn't been released at the time of this trial court ruling, or the issuance of the warrant, would support what we had as far as one of the conspirators saying, hey, I was contacted by phone, I was picked up, there was another, magically, right, there's another co-conspirator sitting in there. There was a plan that involves the defendant, right? So if he wants to say that nothing in the warrant mentions the defendant or has any implications there, the defendant's part of the plan. And so, you know, he proves that out as far as being in his Challenger, in his vehicle, and ferrying the man who contacts Delacy Williams throughout part of this operation. So we have more than simply the tandem operations. We have somebody saying, I used my cell phone for this, and it seems incredibly restrictive and reductive to say that a magistrate could not make a reasonable inference that added to the in-tandem operation, added to them finding the phones on them, and of course the Stocker opinion mentions several cases, including, I want to say, Gallagher v. State, 2023, Westlaw 3085768, Abel v. State, 2018, Westlaw 2694559, Reyes from a different jurisdiction, 174 Northeast 3rd, 138. And they're talking about having their phones on them as something that's relevant there. And in Stocker, a now published opinion of this court, and that's the same thing here. They're found in medias res with their phones on them, and one of them has a gun, and they're chasing this vehicle. And all those things together are clearly enough for a magistrate to have at least a reasonable inference, less than 50%, that they would have evidence that was relevant as far as their communications, their planning on their cell phones. Now let's talk about those cases and also I would say that the defense mentioned that the Stocker opinion today got it right. And one of the things this court cited again was facts suggesting a likelihood of evidence based on them having the phone not being recovered from the residence in Stocker, but being found on his person when arrested. So if that's how he believes that it got it right, then it supports the state. As far as the other cases that he mentioned, I would point out first off that Frazier, as you know, being up on review to the Court of Criminal Appeals, says nothing until we get an opinion from it. And as far as the Court of Appeals was concerned, without any mention of cell phone in that affidavit or cell phone use, that was held to be sufficient. As far as McDonald, again, this is something that we point out is not saying what the bare minimum is. It's just saying that there it was enough. And again, that's specific circumstances. That doesn't even have to operate off of reasonable inferences, which the defense would read completely out of what the proper standard is, as recited by Stocker. Here, as far as Mason, porn was seen at their residence. That actually directly supports what the state says, because there it had no mention of electronic devices, and yet that court was able to say, oh, well, we can infer that that's something that's going on here. And we have somebody who has, you know, he wants to talk about the direct link between Hunt and Williams, saying their communications. But Williams implicates the other co-conspirators. So I don't understand why that has to be read out. I think those inferences are allowed, so Mason supports us. Frazier, again, I think I've talked about. I know also that this court would be aware that Staley has come out from the Fort Worth Court of Appeals. I would point out that there is actually distinguishable language on its face that supports this case being distinguishable from Staley. In Staley, by its own terms, it talks about how the affidavit does not allege any factual connection or nexus between the offense under investigation and any of Staley's electronic devices.
So in Staley, I'm not familiar with it, that's an insufficiency case?
That's one where they found that there was insufficient probable cause, but there, of course, unlike here, we have no recitations about any belief that there's going to be anything found in the phones, why that is, and the basis of that. And of course we do here. We have paragraphs beyond boilerplate that say, I believe that we're going to find conversations, texts, things like that. It says, notably absent is any averment that evidence of, pointing to, or somehow connected with the suspected offense might be found on or within any of Staley's electronic devices, nor does the appearance propose that based on the foregoing probable cause exists to seize or search the devices. Nothing more is said really than that computers, etc. were probably in Staley's house, an unremarkable statement in late 2010s America, but a free-floating assertion altogether unconnected. Your Honor, we have two vehicles operating in tandem added to a co-conspirator's implications. And not to sort of belabor this point or beat this dead horse, but that is not only distinguishable from all of the other cases, it's supported by Diaz, where we have, I think Justice Jewell went and talked about how they had phones, and even if the phones were left there, the phones were present, and that's the point. That is the larger point that Stocker reaffirms here. I would briefly move on to say that I'm not hearing any questions about the second point of error. I would simply offer it to say that we stand on both the lack of preservation on that point, as well as, if the merits were to be addressed, the fact that the defense brought that up first outside the record, and so the state was responding to that. But even if you were to look at the merits...
But don't you agree the statement was improper, even though it wasn't, even though the defense attorney did open the door?
It's not a statement I would make. But what I would say is...
The judge sustained it.
The judge sustained it.
Thought it was improper.
The judge sustained it, but I would say that even that would be something where, and the judge doesn't give, it's not requested as a curative instruction, Your Honor, but the trial court does say something like, remember the evidence. I'm paraphrasing, of course, I think. And even then, you also have the jury charge part of it. This is something that a curative instruction, it's just mentioned briefly in the defense brief, it is something that a curative instruction would have cured. We even have case law in which things such as commenting on the defendant's failure to testify, the most egregious thing you could think of, has been found to have a curative instruction actually possibly able to cure it. And so in this case, we would argue that the curative instruction we presume the jury would have followed it. It would have cured this too, and the defense simply didn't make it. But even with that, if you look at the three Mosley factors, you have the statement being, albeit repeated, brief, the refocusing on the compelling evidence that actually showed, and I know it's separate from this warrant thing, but showing in fact the use of a cell phone to coordinate in exactly the way of being a spotter that the defendant was suspected of doing in this later arrest, and as well as his geolocation data, which the defense does bring up, as well as the possibility of a curative instruction that under the three Mosley factors, it would be effectively harmless. It wouldn't be an abuse of discretion to deny mistrial. So,
Thank you.
I don't really hear any other questions. I'm going to turn it back to the remainder of the time.
Thank you.
I should mention right from the start that I still believe that Mr. Moore is entitled to relief on the second claim. However, I believe that the law is pretty clear there, and so on my request for oral argument, I'd only missed from the first claim. But I do believe he's entitled to relief on that second claim, and I'm by no means trying to drop that claim or waive that claim by not mentioning here. If acting in tandem and just showing up were enough, then the CCA, I think, would have overruled Baldwin and Stocker.
Well, there is one fact that we didn't mention during your opening that's in the affidavit about after the two vehicles left the Galleria area and they were heading to the Johnny Dang. It's noted that they both pulled over together, and then somebody got out and took the paper plate off the car, and then got it back in the car, and then they both took off again together. I mean, how do they do that without communicating over phone? I mean, what
I think they
plausible?
were following pretty closely, and they were following this SUV.
I mean, how does he know the guy's in the, how does he know the other car is going to pull over to change the license plate and then get moving again if they're not talking on the phone or texting?
The question was asked, I believe, by Chief Justice Christopher, maybe it was you, Justice Schul, about who was in the lead. And I don't think that that's in the record anywhere. That would be an interesting fact to know related to your question here, because I believe that if Mr. Moore was behind, it would be easy to follow behind and stop at the same time the tracks did without communicating. It'd be a little bit more difficult. I agree. If he was in front, I don't think the order of the cars is in the record. I don't think even if Mr. Moore was in front, that would necessarily be required. Again, you know, he could flash his hazards or something like that. And I know counsel for the state likened my example with the flashers to smoke signals and everything, but I think that that's not really fair. We signal things all the time when we're driving with our lights, right? Look out, there's an officer coming up, I'm flashing my left brights at you. People know what that means. You know, this isn't unheard of that people use their lights like this to signal things, and I think that very well could have happened here. But even if it's not what happened here, we don't have anything.
But we can't rely on that under Baldwin for purposes of probable cause. I mean, we can't say, well, criminals flash their lights, you know, when they're signaling each other, and think, but you want us to take that into account.
I'm just saying there are other possibilities. That means that a reasonable inference doesn't necessarily mean that they would have to use the phones. I'm just using that as a reason you shouldn't believe that they had to use their phones to do that. And I think that that's allowed. And I see my time is up. Thank you.
Thank you very much. Thank you for your arguments. The case of Moore versus the state of Texas is submitted, and you all can be excused, and we'll have our next argument.
I reserve 5 minutes for rebuttal. May it please the court, my name is Keir McAlpin, and I represent the appellant Robin Nelson, whose foot and ankle were fractured when she stepped into a pothole at the Methodist Sugar Land parking lot in June of 2016. She was wearing a slip-resistant nursing shoe that became caught in this approximately 2 3/4 inch pothole. And she fell and she sustained serious injuries that required her to have surgery. There was a trial in this case in October of 2023 where a unanimous verdict found for Ms. Nelson. Previously, an MSJ, a motion for summary judgment, had been denied on the issues of open and obvious and the existence of an unreasonably dangerous condition. 2 directed verdicts on those same issues were denied during the course of trial, and on the last day of the trial court's plenary power, the court signed a JNOV, and the JNOV motion in particular raised a new issue that hadn't been a matter of law issue raised previously during the proceedings, which was that the defendant didn't have actual knowledge of the condition. However, the way that that was argued was essentially a conflation of 2 separate and distinct legal elements of premises liability: the existence of a condition that poses an unreasonable risk of harm and the actual knowledge of that condition. So the JNOV of the trial court should be vacated, and the judgment of the trial court based on the jury's verdict should be reinstated for 3 reasons.
The first is that legally sufficient evidence showed that Methodist had actual knowledge of the condition. The appellee erroneously conflates actual knowledge of a condition with essentially subjective knowledge that the condition is dangerous. And I'll discuss that at length in a few minutes. Second, there's legally sufficient evidence that the conditions pose an unreasonable risk of harm. There was a complaint by patient liaison Caitlin Mahoney, an employee of Methodist. Her admission against interest was admitted at trial over no objection, where it was stated that she told Mr. and Mrs. Nelson that she was aware of the potholes in this area, that she had been complaining to facilities at Methodist, asking them to get those fixed, and that they were fighting her essentially. And just by way of background, the pothole that Miss Nelson's shoe became stuck in was part of sort of a constellation of about 50 or more potholes in this particular area of the Methodist Sugar Land parking lot. These were not naturally occurring holes. Rather, the evidence was, based on the corporate representative testimony of Mr. Sean Sevi for Methodist, that a water main had broken and pipes had ruptured beneath the parking lot in about 2012, and that due to a leak into the groundwater that had created these holes, and that he also further testified that extensive repairs were needed in order to restore this to its original condition.
Do you agree that this doctrine of common conditions that's talked about in McIntyre and the Canales case applies here?
I believe that the common conditions doctrine must be considered. Do I believe that this is a common condition that would not be considered a condition posing unreasonable risk of harm? No, for several reasons.
Of the factors that are listed that govern this common condition analysis, are any of those dispositive? Or given greater weight?
Well, there are a couple of things that I think are pretty critical from the record. First was that both the corporate representative and the expert of Methodist admitted that potholes are dangerous. So that evidence specifically does address it. Additionally, regarding the common conditions doctrine, I think Mahoney's reporting to Methodist that these holes are here, they need to be repaired, that testimony does satisfy the requirement of evidence of, for example, a complaint. While it's true, and appellant acknowledges that there's no prior injury event, there's always a first time, and it's specifically mentioned in every case that I've read that addresses the common conditions doctrine that a complaint about a condition would be considered evidence that would go beyond a mere common condition and what would potentially be a condition posing an unreasonable risk of harm. Certainly the evidence of that complaint, as well as the admissions of Methodist expert and their corporate representative, those all raise fact issues, and at that point it becomes it's a matter of legal sufficiency. There is legally sufficient evidence, and inferences against the jury's verdict shouldn't be indulged to reach a different result.
Is the complaint aspect, generated complaints, to the dangerousness or just to the condition itself? I mean, you know, you can see things that don't look right and you might want to have it fixed, but that doesn't necessarily acknowledge that you think it's dangerous.
Well, I mean, if the complaint had been, and the evidence had been in trial, that she wanted them to be fixed because they were unsightly or that they didn't look right, an aesthetic complaint, then I think that would definitely change the court's analysis. But where the issue was in the wake of a fall happening, where Caitlin Mahoney had told Mr. and Mrs. Nelson that she had been on maintenance to try to fix them and they had been fighting her, I think it's a reasonable inference for the jury to conclude that the reason for that complaint was that they were a safety issue, consistent with the way that essentially all the witnesses in the case testified. And there's also this open and obvious issue that had been raised. You know, in premises cases, there's a constructive knowledge standard that requires, you know, a plaintiff to prove conspicuity, longevity, and proximity in order to establish constructive knowledge on the part of the landowner. And there's no question in the case of a licensee case like this one that actual knowledge on the part of the licensee extinguishes any liability. And there's equally no question that Ms. Nelson had no knowledge of this condition. She testified she didn't see it. There's no evidence that she saw it.
But the jury put 50% on her.
They did, Your Honor, and they...
What do we make of that?
Well, I thought that was, I mean, that's how they looked at the fact she was on her cell phone, which explains some of sort of her situational awareness. She was in the parking lot. She had just stepped from the sidewalk onto the parking lot, maybe 2 or 3 steps, and she was looking for her daughter and her husband because they were going to go to dinner. And she was on the cell phone looking for them. It explains to some degree her some sort of lack of situational awareness, and the jury assessed that at 50%, which certainly was their right to do.
Well, just because someone is distracted and doesn't see an open and obvious condition, that doesn't turn it into a not open and obvious condition.
I understand that, Your Honor, but based on my review of the case law, I'm not aware of a single case where a court finds that as a matter of law, a condition was open and obvious, absent a entrant onto the land's actual knowledge of it. For example, in addressing this point in the appellee's brief, they cite to approximately 10 cases that I went through in the reply, all of which deal with a condition that somebody actually saw. So if a condition must be so open and obvious that it would discharge any duty on the part of a landowner in order for it to operate as a bar to the duty of care, but certainly if there's a fact issue about whether or not it's open and obvious, the jury can certainly assess that as comparative fault. As you know, the Supreme Court of Texas, as far back as 1962 in the Harvey versus Steele case, which I cite, states is that if it doesn't operate as a complete bar, certainly it can be addressed as a matter of comparative fault. And I think that that's exactly what the jury did here, and I think it was appropriate. I don't agree with the percentage allocated to Ms. Nelson, but certainly it's within their province to view the evidence that way. I mean, the evidence that it wasn't open and obvious, I mean, just under City of Keller standards, she's looking for her family. She doesn't see it. She doesn't have prior experience in this parking lot. She doesn't have a duty to inspect it. And the fact that she didn't see it and wasn't aware of the danger and didn't appreciate the danger prevents her from essentially consenting to the risk, which is the way that the open and obvious defensive duty of care operates, is that if you choose to come onto the land, you're essentially assuming the risk of this condition. And if you step on a wet floor that has a sign on top of it, it's the same principle, which is that you sort of voluntarily assume that risk. And I don't think there's any evidence of that on the part of Mrs. Nelson. And additionally, the color of the concrete is a different color, or excuse me, it's the same color as the pothole. It doesn't stand out. It's not painted in yellow or anything like that. There's no warning that's there. So these facts, I think, make it clear that the jury's verdict should stand and that the JNOV should be vacated.
The pictures and evidence make it look like the divot is darker. Is that just a bad picture that we have?
I believe it's the shadow from the angle. Let me look at it actually. On page 7. Yeah, what I see is that there's a slight difference, but a minor one in the color and the crack compared to the surface, and that there's some additional shading based on the sunlight.
Thank you. You'll have time for rebuttal.
May it please the court, my name is Mark Callender, and I, along with Connie Pfeiffer, represent Houston Methodist Sugar Land Hospital in this appeal. Justices, there are 3 independent reasons the trial court's judgment, notwithstanding the verdict, should be affirmed. First, the spalled concrete at issue did not pose an unreasonable risk of harm as a matter of law under the Common Conditions Doctrine. Second, the spalled concrete at issue was an open and obvious condition, thus relieving any duty to warn or take steps to alleviate any risk associated with that condition. And third, and importantly, there is no evidence in this record that Houston Methodist Hospital had actual knowledge of the danger as is required in a licensee premises liability case. Now, before I turn to the crux of my argument, I'd like to...
Actual knowledge of the danger or actual knowledge of the condition?
It's actual knowledge of the danger, Your Honor, and for a couple reasons. One, and we could go straight to that issue with Osterberg versus Peka out of the Supreme Court in Texas in 2000. What that case tells us is, in a sufficiency challenge like this, a legal and evidentiary sufficiency challenge, we look at the charge that was submitted to the jury, not some other identified area of law, not the charge that appellant argues should be submitted, but the charge that was submitted. And at the clerk's record, page 637, you'll see the charge specifically says Houston Methodist must have actual knowledge of the danger, which is consistent with PJC 66-5 for licensee cases, which specifically requires actual knowledge of the danger. The next response point that I would like to make is, I want to clear this up, and I think the photos in our briefing at page 3, they're at the record, page 9, volume 4, clear up that this is not a pilot. There was one premises liability expert who testified in this case, Linda Porras-Pirtle, and she testified this is a naturally occurring spalled concrete. She described how it occurs through water leaking into the concrete in a freeze-thaw process. Also importantly, uncontroverted testimony at trial from her, the only expert, that it measured 3/4 of an inch to 1 inch. The 2 3/4 inch that appellant's counsel argued is the measurement of Ms. Nelson's heel. Our expert looked at this, said it was 3/4 of an inch to an inch. Ms. Mahoney, who went out there the day of and the day after, believed, and this is in the record, that it was less than 1/2 inch. Now, secondly, appellant's counsel, as your Chief Justice pointed out, he confuses the standard here. It is actual knowledge of the danger, not actual knowledge of the condition. Now, turning to the main bases why this court should affirm the JNOV. Again, under the common conditions doctrine, the spalled concrete did not pose an unreasonable risk of harm as a matter of law. I think the best place to start in that analysis is with the United Supermarkets versus McIntyre case out of the Supreme Court in 2022. That case is directly on point and very similar to the facts that we have. And
I think his argument for the differences has to do with Mahoney's testimony, or what was said to be Mahoney's testimony here. So why is that not an issue here?
I understand, Your Honor. So, and I agree with you. I think the courts look at prior reports, prior accidents, prior complaints, and I would say there is testimony from Mr. Nelson that Ms. Mahoney reported it, but just the report of a condition is not the report of a danger.
Did she report the spalled concrete condition, or did she report that there had been other instances?
She didn't. Her testimony is that she didn't do either. Her testimony at trial was that she hadn't seen it until after the accident.
What did Mr. Nelson say?
Mr. Nelson testified that she told her that Ms. Mahoney told Mr. Nelson, I had seen these, I had reported them, and asked them to fix them. That's it. And I think I understand what you're saying, Your Honor. Had the testimony been different, had she said, I'm reporting these, I believe they're dangerous, I think if we don't get them fixed, somebody's going to be hurt.
Well, or someone else had fallen.
Or somebody else had fallen. That may be.
But no one said that?
No, not at all. In fact, to the contrary, Justice, Mr. Seavey, our Director of Operations, testified he's been there since 2008, 15 years. He had never had any prior reports, complaints, or accidents. And he went further to say, he calculated about, because they did a study on how many people come and go through that hospital parking lot, he estimated about 1 to 2 million people a year come through that parking lot. He had been there about 15 years. This was the first accident that had been reported, and he testified at trial. This incident was the first time he'd even heard of or of the spalled concrete. So this was a new issue. So if we take McIntyre and we look at the facts of McIntyre, they're squared up with this case, Your Honor. We've got a 3/4 inch divot there. We have a 3/4 to 1 inch divot here. No previous injuries, complaints, reports there. The only report that we have here would be Ms. Mahoney. If Mr. Nelson's testimony is taken as true, and I'll get to that when I talk about actual knowledge, but if it's taken as true, that would be the only report. And then the courts look at, was it naturally occurring? In McIntyre, that pavement divot that the customer tripped in and with her heel, they said it was naturally occurring. Here, our expert, which was the only expert in the case, testified this was a naturally occurring process, spalled concrete, not a pothole, and that, and she explained it was from the water seeping in and a kind of a freeze thaw issue. So if we take that further, in 2024 in Pay and Save versus Canales, the Supreme Court again applied the common conditions doctrine. Now it was a supermarket case, but it was a little different. It wasn't a surface condition case. There was a wooden pallet. The gentleman was there buying produce. He slipped, stepped in the pallet, slipped and broke his elbow. And there's some really instructive language that comes from the Supreme Court in that case. Again, they focused on the prior accidents, prior reports, were there any regulatory violations that came up in that case. And in holding that the wooden pallet did not pose an unreasonable risk of harm as a matter of law, the court said, these are the types of hazards we encounter every day and we can avoid with prudence and caution.
Yeah, but at least in Canales, though, there was nothing actually wrong with the pallet.
True.
The fact that there's an open end on the pallet is just a natural condition of a pallet, and the guy needs to put his foot in it.
True.
But the parking lot is not supposed to have spalled concrete in it, though.
And McIntyre also said that they're making no broad pronouncements on whether pavement defects constitute unreasonably dangerous conditions.
I don't disagree with that, Your Honor, but if you square up the facts of this case with McIntyre, they hit all the way. In fact, I would say this is probably a more compelling case because if you look at the photos, the spalled concrete is a deterioration, and I understand that it's argued that it took extensive repair work, but this was cosmetic. This is cosmetic repair. And so it's not, and again, I'll, this court also applied the common conditions doctrine just last week in an opinion that you issued in Morales v. Buc-ee's and reviewed some of this. This court focused on some of the same things, whether prior accidents, prior injuries, prior reports, code violations. And so if you look at the evidence in the record here, if you take those three cases, McIntyre, Canales, Buc-ee's that just came out of this court, and you apply it here, you have Mr. Seavey's testimony saying no accidents, no injuries, no reports, with 1 million or 2 people coming and going. And then you also have Ms. Pirtle's testimony, the only expert in the case, that this was not a regulatory noncompliance and it wasn't a code violation. You take all those together.
But we have the Mahoney statement.
We do have the Mahoney statement, and I'd like to move to that if I could talk about open and obvious, and then we could move to the Mahoney statement, or would you like to go there first?
Okay.
Okay. And I'll be brief on the open and obvious. I mean, the Valdez case tells us out of the Supreme Court in 2021 that there are some conditions that are so open and obvious and visible. We look at the totality of the circumstances, and we ask, what would a reasonably prudent person appreciate about the danger? And I think when you look here,
But doesn't that kind of undercut your argument that it's not dangerous?
I don't think so, Your Honor. I think it kind of adds to it. It's not dangerous, and it's so open and obvious that even Mr. Nelson, in the record, Ms. Nelson's husband testified, and I could quote him. He said, you could visibly, and it's obvious. And then our expert confirmed that by saying it's very visible, and you can avoid it. So I don't think it undercuts it. I think there are two separate arguments. I think it's not unreasonably dangerous as a matter of law, because it's a common innocuous hazard that this court talked about in Buc-ee's. And then I think it's also, there's no other evidence in the record that it couldn't be seen. The only evidence in the record is that it was open, obvious, and visible. And I think it's the type of hazard that we all encounter every day and avoid. Now, I think moving to the point that Your Honor wanted to talk about, the Mahoney report. There's no evidence in the record of actual knowledge of the danger. At most, the Mahoney report that she had seen these and reported them would get actual knowledge of the condition. But that won't suffice here. As we know, the charge that was submitted was actual knowledge of the danger. So when we look at knowledge, there's two things that appellant relies on here. The Mahoney report, which, and interestingly as well, Your Honor, not only would that only get them actual knowledge of the condition, Ms. Mahoney testified at trial, and this is in the record, volume 2, page 110 and 11, that she didn't believe it was dangerous. So even if she did see it before and report it, and we take that testimony as true, it doesn't get them to actual knowledge of the danger, which is required here. This is a licensee case. Now, the second piece of evidence that they rely on is even of lesser value. It is general campus inspections. So they argue circumstantial evidence of general campus inspections means that Houston Methodist must have known of this danger. Now, when I first look at that, I think, well, that's a constructive knowledge argument. That would be something you would consider in an invitee case. This is a licensee case, so it's not applicable. But nonetheless, the Texas Supreme Court in Union Pacific versus Prado considered this exact issue. In that case, you had a licensee who was driving across a private ranch, was hit and killed at a railroad crossing. The circumstantial evidence there relied upon by the plaintiff was that there were 4 prior accidents there, and that the rancher's son knew of one of them that was a fatal accident. And in considering that evidence, the Supreme Court said, and that's in 2024, if circumstantial evidence is used to prove actual knowledge of danger, it must rise to the level of a virtual certainty. And if we look here, the only evidence in the record on this issue is Mr. Seavey testifying that the hospital does weekly, monthly, and annual inspections. That's it. There's no evidence that those inspections led to reports. There's no evidence that those inspections led to the discovery of spalled concrete or a dangerous condition. So if you apply the Prado analysis, that general circumstantial evidence is even less compelling than Prado, and you reach the same result, which is Houston Methodist Hospital did not have actual knowledge of the danger here. For these reasons, Your Honors, 1, the condition did not pose an unreasonable risk of harm. 2, because it was open and obvious condition. And 3, because Houston Methodist Hospital did not have actual knowledge of the danger, we ask that you affirm the trial court's JNOV.
Thank you.
May I proceed? The single most important case that's the most decisive and the most helpful in the appellant's favor on the issues that we've just heard is the Albertsons LLC versus Mohammadi case from the Supreme Court of Texas in 2024. This sophistry with including this new argument about the charge and how the charge says the danger and the case, I believe they said Osterberg, I don't remember the exact name of the case, but it wasn't in any of the briefing. Albertsons addresses even this issue. Specifically, Albertsons states that to answer the question about actual knowledge, we must first correctly identify the, quote, danger or condition at issue. If the relevant danger is the wet floor, then there was no evidence before the jury that any Reynolds employee actually knew of the danger. So this case solves this essentially wordplay conundrum about is it knowledge of the danger or knowledge of the condition. They're essentially interchangeable, meaning the actual condition. In Albertsons, the danger or the condition is the wet floor. It is not the subjective appreciation on the part of Albertsons that the wet floor is actually dangerous. And the conflation of actual knowledge with appreciation of the danger that they're asking the court to make, and they ask the trial court to make, is actually an extremely dangerous argument for the jurisprudence and premises liability in Texas, because it would essentially create a gross negligence standard, or a standard that's akin to gross negligence, where not only would a landowner need to know that a condition is there, the landowner would actually have to subjectively appreciate the degree of danger and then not care and then fail to act. And that is part of the legal standard in a trespasser case. It's part of the legal standard in a gross negligence case. It's not part of the legal standard in a licensee case. And it shouldn't be.
But it seems to me that there's a difference between, yeah, I'm looking at this concrete and I see a 1.5-inch, 2-inch divot versus a pothole, right? Where you could see somebody putting their whole foot in it and falling. This is kind of a freak accident that her heel caught in this small divot.
Her entire foot caught in a pothole that was the exact length of her shoe. And
But I mean, if you're just looking and you're looking at that picture, I'm not seeing a pothole. You know, so and if the testimony is that it's, 1 inch deep, that to me is something different than a pothole, but that.
Well, it becomes quite difficult, Justice Christopher, for there to be a bright line legal test as a matter of law to decide this.
Sure.
And I think
I
that's
agree.
part of why the court in McIntyre is so circumspect about its holding. I mean, in that case, you have a stiletto going into a pinhole divot, which is completely different, I think, than a case like this one where you have 50 plus of these holes and a slip resistant nursing shoe gets caught in it. So I simply don't believe that it's a comparable or parallel case. Additionally, I wanted to say a couple things briefly about open and obvious. There's contradictory evidence that's introduced by Methodist on open and obvious that precludes judgment as a matter of law on open and obvious. Mr. Callender mentioned the inspections. There were 7 layers of inspections over several years. I did the math during trial. There's evidence that it was approximately 12,000 inspections. And Mr. Sebi testified we never saw these. So I don't believe that testimony was very credible, but if 12,000 inspections didn't yield Methodist noticing these conditions, how are they so open and obvious that Ms. Nelson, the first time she steps into the parking lot, who'd never been there before, it's so open and obvious that she should have seen it. And this was argued during the case, and just their contradictory advocacy on that point, I think, creates a fact issue by itself. And the Morales versus Bucky's case, that's about a chair that wasn't even designated for use, where there was no evidence that it had any defect. I read that case this morning when Appellee's counsel brought it to my attention. It has no bearing on this matter. And again, on actual knowledge, Pirtle testified, the expert testified, Methodist probably did see it. That testimony is in the record, that their expert testified they probably saw this, which given the 12,000 plus inspections they did, they probably did see it. And Ms. Mahoney saw it, and she reported it. So the JNOV should be vacated and the prior judgment of the trial court reinstated. Thank you.
Thank you. Thank you for your arguments in Nelson versus Houston Methodist Sugar Land Hospital, and we are adjourned.
All right.